The first section is rather possibly adventurously called Facts, Fiction and Today's Debates, perhaps possibly suggesting that today's debates don't come under the heading of either facts or fiction. So, I'm going to operate on the basis that the speakers are going to go in the order which they're listed on the agenda, just so that people know what order they're in. I hope I've got that right. So that means that Anne is going to start us off. Anne's a Professor of Law and Public Policy at the Oxford University Faculty of Law and a Fellow and Tutor in Law at Brasenose College. I'm not going to go through everybody's introductions, by the way, because you've got them all in your packs, so you can find out more about the people that you're hearing from those packs. So Anne, please, if you'd like to kick us off.
I was delighted to be invited to this event. It's so difficult to get any kind of reasonable discussion going about EU employment law because, of course, the EU is very controversial, employment law is very controversial, and you put the two together and you get a very explosive combination. So I really welcome this event and the accompanying pamphlet. I'm going to take advantage of speaking first to suggest a few topics that I hope we can consider in the course of today's discussion. And I'm going to pick out two substantive issues and two more procedural issues that I think we might usefully focus on. So to start with the two substantive issues, I hope we can spend a bit of time today talking about EU labour law and its role in addressing the economic crisis. That's already been mentioned, and obviously it's at the forefront of our minds at the moment and at the forefront of the EU's concerns. So what is the role of labour and social law in the context of an economic crisis? Well, of course, one reaction would be to say, let's deregulate, let's take away worker protections in order to make things cheaper for firms. But that may not be the most sensible approach to dealing with this kind of problem. Just throwing out the whole of EU labour law may not be the right response at all. So let's think in a bit more detail, I hope we can think in a bit more detail about some of the specific features of EU labour law that might be relevant in an economic crisis. So, for example, do we have the right framework in place to deal with corporate restructuring and the impact that that has on workers? Do we have the right consultation frameworks in place, for example? Is the EU doing enough with the structural funds to address areas and regions which have a problem of very high unemployment and lack of appropriate skills? So EU labour law and the economic crisis is one heading I think we might usefully explore. A second heading, and I hardly need to mention this, is the internal market and the place of labour rights within the internal market. I think we can pretty much automatically assume that people will want to talk about that. Of course, as we all know, the EU internal market is post-enlargement a big and diverse place. For people in countries with low average wages, it's a big chance to better themselves, to come somewhere where they can earn more. For people in the older member states, it can seem like a threat. Their employer might relocate to another EU country using its freedom of establishment, or it might take advantage of workers posted from other countries in order to undercut their terms and conditions. And of course, as many of you will know, the court's decisions in Viking and Laval and other related cases don't really seem to give enough acknowledgement to the EU's social dimension. And I hope this is something that we can explore in a bit more detail. It seems to me that there is a clear need for some reform here, but we have to be realistic in what we can expect. EU law has its own sort of logic, and the market has its own sort of logic. It seems to me that collective bargaining and the right to strike shouldn't be subordinate to the features of the internal market, but equally those rights can't be unlimited either. So those are my two substantive issues. I've got two procedural issues that I think we might also usefully think about. The first of these, I just want to throw into the mix, and I don't really have any kind of solution to it as a problem. But a lot of EU labour legislation results from politically fraught discussions and compromises, and politically fraught discussions don't generally produce good law, not in terms of something that you can read, understand, and easily apply. Just to pick out a couple of examples, the treatment of on-call time in the Working Time Directive, where the court has done its best, but really the legislation was badly drafted in the first place. And I think also, to take a British example, the 12-week qualifying period that the UK negotiated in the agency work arrangements, I think has made that legislation infinitely more complicated and difficult than it needed to be. So there are lots of problems in the detail, and I think that's a real issue, and it's one that's very difficult to resolve, but somehow we need people to generate less heat and a bit more light in this area. And finally, my second of my sort of procedural points is that I hope we can talk a little bit about the role of the Court of Justice. This is, I guess, a pet interest of mine, really. But it's important to remember that the court plays a very big role in developing EU social law. It's not just about legislation. And I think now that the court deals with such a diverse range of law and legal issues, there's a strong case for creating a specialist chamber within the court that could concentrate on employment and social issues. Although the court's responsible for what I would regard as some of the best bits of EU labour law, particularly in the discrimination field, it can also mess things up by not completely understanding the context in which it's making decisions. And of course, Viking and Laval would be a good illustration of that. So I hope that that's something we can talk about as well. So that's me done. That's 4 suggestions. I'm sure there'll be many others as well. Thank you.
Thanks very much indeed for that, Anne. I particularly like the suggestion that we generate more light than heat. That this is perhaps not necessarily in the best traditions of this room. John, maybe you'd like to go next.
What an introduction! Thanks, thanks, Owen, for that. It was worse when there was smoking in this room. That era is gone. Well, it's a very good initiative today, very topical one, and Greece is on strike, another general strike, which gives a certain dose of reality to the present state of many of the features of the European Union. And I think it's true to say that even on an optimistic scenario, that for the EU in 2012, it's going to be a year of austerity, it's going to be a year of recession, of rising unemployment, and of falling living standards. And we know what that tends to produce. It tends to produce people turning against the euro in those countries in the Eurozone, against the EU, and we're aware of that in this country, against immigrants and migrant labour, against the single market and free trade. And it was no surprise at all to see a rise in nationalism in quite a lot of countries. And most of us who are interested in Europe are watching very carefully the Le Pen performance in the forthcoming French presidential election. And that's the optimistic scenario. The pessimistic scenario is much more fraught, and it's whether the Eurozone will collapse, whether Greece, possibly Portugal, will default, and whether there'll be any contagion on a broader scale from any of such problems like that. And this is economic policy primarily, but it's social policy as well. And it's very much linked now, intertwined with these social Europe issues and debate. If you look just in Financial Times today at the demands of the EU finance ministers on Greece, on all the political parties in Greece, is about cuts in the minimum wage, about changes in pension arrangements, and changes to the private-public divide. I mean, this is detailed surveillance and engagement in the internal affairs of Greece, that's for sure. And from my experience, which I'm probably 6 months out of date, the Greeks were seeing it then as a bit like a relegation to colonial status, as they were under the Germans, as they were under the Turks. And florid language like that was all around the place. So it's the way out of the economic crisis, in terms of the one view of it, and that tends to be the German view of it, is curbs on public spending, structural reforms, by which they mean basically weakening worker protections and union rights. And they mean, I think, that in the hope that the short-term pain will be balanced by the long-term gain, that the productivity will rise, that costs will reduce, productivity will rise, and growth will resume. And that's the strong German government view. It's what they would do themselves to themselves, and what they've done to some extent. It's not just preaching it at others. That's when the euro came in, they thought they were a bit certainly overvalued against some of the other currencies, particularly the French franc, and they held labour costs steady for 10 years. And they did that, by the way, with the consent of the trade union movement at that stage in Germany. So this is not a medicine that they're prescribing for others. It's a medicine that they've taken themselves. And I think that anybody looking around at the different countries of Europe now who's doing reasonably well in the crisis would say that I call it the North Sea countries, apart from us, the North Sea countries are doing the best. Germany, biggest by far. The Dutch, pretty good. The Nordic countries, pretty good as well. And they're the ones who still prize manufacturing, old-fashioned virtues like saving, old-fashioned virtues like being good exporters, and really running an economy which is not overly dependent upon property speculation and financial services, which has been our great weakness and has led us to the present difficult position in the UK. Of course, there's another view, and it's a view that I subscribe to, and I say one of the reasons I welcome this kind of conference today is that you can discuss the criticisms without being thought to be against the European Union project, because I'm very appreciative of what Europe has done, not just in the social sphere, but in terms of bringing countries together after the very difficult first half of the 20th century, and the difficult period of the communist regimes in a range of Eastern European countries. I think what Europe has done is inadequately recognised in this country. But in a way, the challenge is now, and can it come through this? And the other view to the German one is that actually shrinking output, increasing debt, there won't be a long term unless you change that in some of these countries. They won't pull through like the Finns did after the collapse of the Soviet Union in the early 1990s. They're not structured like that. Their culture is different, and the better guide to these countries is what the Americans did in the end of the Second World War, which was Marshall Aid, which incidentally was the first recipients of Marshall Aid was Greece. And it was a price the Americans were prepared to pay to keep the communists out, if I can put it crudely, but also to engender growth in growth in the economy to bring some prosperity to a hard-hit Europe. But the underlying reason was political. But I do believe that the rather less in the, as I've said to President Barroso and others, less reparation type approach and a more open-handed approach would be the only way to get out of the mess that we're in. Of course, the Germans have got a point that they say, you know, we're not listening necessarily to the Keynesians in the English-speaking world, or indeed even in France, particularly in the English-speaking world. You've got yourselves in a hell of a mess through your own bad practices. But that has led them, I believe, into a pointless new treaty, which is more strict rules for economic prudence and rules which most of the countries in the European Union will find it extremely difficult to comply with. So it's a tough scene, and I just want to emphasize it is about the social side, because underpinning this is a view that some of these countries in particular have got to get cheaper, that their unit labour costs have got to be reduced, and that in future that unit labour costs will have to be benchmarked against Germany, either on productivity grounds or a lot cheaper than they are at the moment. And that is the majority driving force, particularly because Germany's insisted on it, in the European Commission and elsewhere. It'd be interesting to hear Laszlo Andor's view on that. Well, that's one side of it. The other side that I just want to touch on briefly, on another minute and a half or so, is the point that Anna's been talking about the single market. I mean, before the crisis, the whole of this conference would have been about the single market, free movement of labour, and how does that impact on collective agreements and union rights. Someone said in this room at some conference I was at a year ago, it was an accident waiting to happen. The free movement provision up against the national labour systems of particular countries. And the Laval and Viking cases, which are described in some of the papers in the booklet that you've got, have now produced a situation whereby if that case law became the general law, that collective trade union action would only be allowed in exceptional circumstances, would have to be proportionate to any issue which is around, and who decides what's proportionate? Not the union, but a third party, the court, no doubt. That all avenues needed to be exhausted, that agreements, national agreements above minimum wages, statutory minimum wages, could only be enforced by industrial action if they were legally enforceable and what are called generally legally applicable, that is, covering all the employers in a particular sector. And so we face the prospect where these migrant workers, particularly the posted worker being the worker who's sent by an employer to go and work in another country, that particular category, which is pretty numerous in the European Union, the agreements, there'd be no requirement really for them to comply with the national agreements in the country to which they're going. Obvious point is that workers from Eastern Europe would come into Western Europe and work well under the Western rates, which is a recipe for all kinds of hostile social reactions, which we saw rather unattractively in Lincolnshire during the disputes around the Lindsey oil refinery in 2009. Remember the British Jobs for British Workers dispute, which took on some nationalistic edges for the first few days until the unions, I think, got a grip of it and eliminated that kind of it, that side of it. So that is this is a major problem area. The Mario Monti, now Prime Minister of Italy, had a crack at it before I left Brussels, and came up with what's called a Monti II regulation, Brendan's gone, but he said the Monty 1 regulation was very much the product of a dispute in the late 90s on the single market and the free movement of goods. And it upheld the right of unions to take action in the single market. Monty 2 is, well, the way it's emerging from the Commission is less satisfactory. It's tending to enshrine the Laval and Viking judgments in European-wide law. And just to say, as Brendan said at the ETUC Congress, he said, what we want is the full Monty. Never mind Monty 1, Monty 2. We want the full Monty. So we're looking more full Monty or Monty 1, but as applied to services and to the free movement of labour, not just to goods. So, Owen, that's my introductory remarks, and those two issues, the crisis and the single market, I think are the kind of points that most of our discussion is likely to be about.
Thanks very much indeed for that, John. Obviously, the reason I didn't introduce you more formally was because you needed no introduction at all, certainly in a room like this where you spent so many happy hours. Right, our next speaker, final speaker on this platform is Karen Clements, who is the consultant on European affairs to the British Chambers of Commerce for 12 years now, which suggests that you're doing it so well that you've been reappointed time and time again. So congratulations for that. Welcome to Congress House. You called your article in our pamphlet a fine balance, or either you called it that, or
I called it
or
that.
Adam and I. Yeah, no, good. That's good.
You may disagree at the end
to
of
blame
this.
you that. But Karen, please.
Thank you very much. Thank you for inviting me here today. Just for those of you that don't know the British Chambers of Commerce, it's a national network representing 52 chambers across the UK. Their business members are roughly 100,000 in number and employ about 20% of the private sector workforce in the UK. A typical chamber member is probably family-owned, probably has about 80 employees, and if it exports to Europe. To the EU more precisely. Today I'm going to focus, as you won't be surprised to hear, on the single market and its impact, its relationship with employment rules. I agree entirely with what Brendan Barber and Lord Monks have said already, that what we need to do is to get Europe growing and working again, and I also agree with the statement that Europe is now less popular than it's ever been before. This is something that Professor Monti also exposed when he was asked to save the single market before he was asked to save Italy. And he exposed this important contradiction that we need the single market more than ever, but it is less popular than it ever has been. The business community would entirely agree with the fact that the single market is the source of growth and jobs in the European Union, and that the EU should, crisis aside, concentrate on completing it and making it work better. It's also undeniable that support for the European project and for the single market is waning drastically. So how do you get popular support for more Europe? Monti's response and the Commission Single Market Act, and I'm not referring specifically here to Monti 2, but to the general approach, was that you need to have a balancing act between market opening measures and increased social protection and increased employment rights. Well, funnily enough, the business community and certainly the chambers don't believe that that's the right way forward, that it's sustainable. They also I would also argue that it's least likely to succeed in the UK, where Europe is officially a dirty word. It may be largely due, this change in attitudes might be largely due to a hostile press that likes to prey on English insecurities and prejudices, but it's undeniable that there is a widely held perception that Europe interferes in people's lives and in the lives of businesses. And employment rules are high up on that level of interference. And there is a basis of reality here. No one denies that legislation is required to build a single market, and even the vast majority of the business community also accepts that EU citizens should enjoy a single set of employment rights so that they can move freely across borders and so that there's no social dumping. But the EU, whether it's the Commission or the Parliament or the Council, has great form in legislating either with good intentions which result in unintended consequences, or in legislating for its own sake. Legislating to increase protection for those in work at the expense of those out of work won't help Europe or the single market to work any better, and it won't make Europe more popular. If you look at agency workers, for example, I'm sure that the Commission did not intend to depress the agency market in the UK. That is, I fear, what's happening today. The latest survey from the Recruitment Employers Confederation shows that hiring of temps is down for the second month in a row, and the respondents cited the agency regulations as one of the reasons for that. Not the only reason, but one of the reasons for that. Equally, if we look at the Working Time Directive, the European Parliament doesn't want workers to have to work extremely long hours if they don't want to. Well, neither do businesses. All businesses want is to be able to have the flexibility to deal with peaks in demand. Also, in the UK, there's a shortage of skills in certain sectors, and the opt-out allows them to deal with that. Also, the opt-out's the only straightforward part of the regulations, and we don't have an infrastructure in this country to allow us to take advantage of the flexibilities that the directive has for those that engage in collective bargaining. I mean, there are all sorts of other reasons, not least because the definition for autonomous workers is very unclear in the UK. It's not just the employees like the opt-out because it enables them to do overtime, and this can, certainly in the current fragile economy, help keep living standards up. That's not to say we can't change the way it's operated. For example, the BCC certainly thinks there's a good case for having a time lag between signing a contract and signing any opt-out, so that you can't be accused of coercing your employees to work longer hours. But if they want to, they should be able to. And the bottom line is the opt-out hasn't precluded more innovative work practices in the workplace. It hasn't precluded many other changes in work practices, because working hours have gone down since 1992. So how do we get that fine balance between the needs of employees and the needs of employers, and how do we ensure that the EU rules are fair without having the unintended consequence of swelling the vast ranks of unemployed and that are sadly growing vaster by the day? The BCC believes that the solution lies in not deregulation, but smart regulation. And believe you me, there is a world of difference between the two. So rather than offset one rule with another, we think you need to have an infrastructure in place that ensures that A, the rules are necessary in the first place, and B, the means are proportionate to the end. We owe, or rather we're completely supportive of the work that the European Commission has done since 2003 to put in place a system that analyses the impact of rules on the economy, on society, on the environment, but also on businesses, and more particularly on SMEs, who always bear the brunt of the unintended consequences of poorly designed rules, as Professor Anne Davies talked about earlier. And it's beginning to bear fruit, this rigorous analysis of the impact. We have a draft directive on ergonomics, which brings together visual display units. That's where you have to have an eye test when you use a computer, and manual handling of loads. That's how much you can, that's bending your knees when you're picking up a load of files, although we don't have files anymore, but anyway, they're all in the computer, laptops, whatever. And the idea is to bring those together, which is a very sensible idea. But in doing so, DG Employment has suggested that if you have a BlackBerry, your employer will need to pay for an eye test, even though there's no evidence to suggest that BlackBerries have an impact on your eyesight. So the impact assessment has, for example, brought attention to this particular proposed rule, and I know that the DG Employment Services are looking at it again before they present their final impact. Another example is the rare use of an impact assessment in the European Parliament for the Pregnant Workers Directive, where extending full pay for all mothers to 20 weeks would have cost the UK 3 billion, the UK alone £3 billion per annum, and that cost was deemed unacceptable in these times. So laws, of course, need to be updated, but they need to take account of the economic circumstances in which that prevail at the time of their updating. We'd go so far as to add there also ought to be a jobs test, that regulatory policy should adapt to economic circumstances, so lighter when times are bad, possibly heavier when times are good. There's a precedence. Last September, President Obama refused to sign a new rule on emission standards because of the cost it would have had and the impact on the economy. So if he can do it, we can. We're not suggesting to row back on existing rights and commitments, but we do think that you've got to let the private sector grow and you've got to let it create jobs. And if the EU and the single market can be seen as a source of jobs and as a source of growth and not of interference, then people might start trusting the European project again. Thank you.
Right, thanks very much, Karen. I think we've now got some microphones for people to ask their questions. And I'd like to take a few questions and then ask the panel to respond. So let's have the first question right at the back so that people don't have to move too far, and then Roger there. If you could introduce yourself when you speak, that would help the speakers know who you are.
My name is Michael McGough. I just want Brendan Barber mentioned this new treaty, which is a treaty of the, is it 2026, and excluding us and possibly Hungary. I want to know what you thought the implications were for our not being part of that treaty, whereas the others are. And, we mentioned talking about growth. Would it not be better for countries like Greece to leave the euro if they want to achieve growth?
Thank you very much. I've seen one there, and then just behind Roger for the next one.
I'm Roger Lyons, and apart from once spending many happy hours in this TUC General Council room, I'm also a member of the Employment Appeals Tribunal, which is a branch of the High Court that deals with employment legislation, and including relevant European directives. And I strongly welcome Professor Davies' suggestion that the European Court should have a branch dealing with social and labour law, and hope that can be fully campaigned for across Europe. The specific question I have follows what John Monks was saying about completion of social Europe, and that is, it's not just a question of social Europe. We have a particular problem with employment law in the UK, where governments of all colours have endorsed a situation where they're in favour of free movement of capital, free movement of labour, but the unions and their members have no rights to be part of any European industrial activity. They're banned by law from being involved in transborder activity. Now, it can't be right that jobs can move freely, that people can move freely, that capital can move freely, But the only people who can't move freely are union rights. They're shackled. So for any completion of the social market, I would suggest to the panel, there needs to be some addressing of this special weakness in the UK.
Thanks very much. And just behind you. Yeah, thank you.
Catherine Barnard, the University of Cambridge. Appreciate the comments that have been made, but I'm slightly concerned, Lord Monks, by your characterisation of the Monti II regulation. As you know, the decisions in Viking and Laval were decided under the treaty, and the treaty is a hierarchically superior norm to any regulation. Now, with the objections to the Monti II proposal, particularly to its reference to proportionality, my understanding is that the trade unions would prefer no proposal at all than the proposal that's currently on the table. The problem is with that approach, it seems to me, is that you fall back on the Court of Justice, which has proved itself to be somewhat unreliable in respect of balancing the social rights of the workers with the economic rights laid down in the treaty. Even if the proportionality clause were removed from the Monti II proposal, proportionality will still apply because it's a general principle of law. And the advantage of having a Monti II proposal, even if it's not quite in the form the trade unions would like it, is that it gives a gateway for access not only to EU law but to the European Convention. And the European Convention on Human Rights and its recent interpretation by the Court of Human Rights in the Demir case has given a much more nuanced and balanced interpretation. And I fear that if the trade unions object to the Monti II proposal in its current form, that the baby will get thrown out with the bathwater, and you'll end up with the position we're in at the moment, that the treaty will prevail and as interpreted by the Court of Justice. And there is really very little sign that things post-Lisbon have got better. Yes, there's a reference to social market economy in the early provisions of the TFEU and TEU, but it hasn't really influenced the way the Court of Justice interpreted the treaty. Thank you.
Thank you very much, Catherine, and thank you, by the way, for the article in the pamphlet as well, I should say. Any other questions before I ask the panel to respond to those? I'm desperately trying to give John a bit of time to think of the answer to Catherine's question. Please, right at the front, sorry. Sorry to our microphone handlers.
Thanks. I'm David Seymour, formerly political editor of the Mirror Group. The worrying thing for me is that from what both John and Brendan said is that that the union movement, the unions are opposed to the non-treaty of the 26, which doesn't mean they're on the same side as David Cameron's non-veto, because of course Cameron agrees on that point of austerity with the 26. It's not the point of it at all. And it does seem, as Brendan was saying right at the very end of what he said, that this is incredibly worrying for the whole European project. And I wondered what the panel thought was a way out of this, or a way forward.
Okay, any other questions? Yes, there's one. I'm really sorry about this, but at the back. Yeah. Hold on. And then I'll move on to the panel. So.
Thank you. I'm Jazz Weir. There seems to be a lot of discussion about the need for greater sort of fiscal consolidation and financial harmonisation generally. Isn't it time to break the whole egg open and talk about holiday harmonisation, pension harmonisation, all the rest of it? You know, if they're going to move to tighter financial controls, and I understand why private firms and others might want harmonisation of taxation and so on, then shouldn't we look for a whole bundle of a social package to compensate?
Thank you very much. Right, so, number of questions there for our panel. I'm going to go in, do you mind if I go in reverse order? Karen, so
no.
I'll let you go first.
Blimey. Right. Should the UK have joined the fiscal treaty? That's a political question, really, which the business community isn't necessarily well placed to answer. I don't think that in terms of Europe's recovery, the UK joining the fiscal treaty will make much difference. Should Greece leave the euro? Well, it probably should for its own sake, but obviously the consequences of it doing so would be potentially devastating. So it's a bit of a catch-22 situation, which would probably explain why they simply are not being able to make any decisions about it, and why this has been going on for such an extraordinarily long time, and why we've had, 17 or 18 summits to save the euro, which clearly haven't done so. Sorry, that's not a very conclusive answer, but that's, I thought...
It's at least as conclusive as the European Union manages. So,
with regards to the union rights across borders, would you mind elaborating on that? Because I'm not entirely sure what that would involve in practice.
do you want to have a quick go at that, Roger?
It's illegal in this country for a union to be involved in any threat or industrial action, threat of or industrial action, that isn't against their UK employer. So in other words, if you're dealing with a company that's based in France,
yes, so that you can't come out
decisions made in Paris,
with another.
you can't do anything about
okay,
it.
Sorry,
absolutely. As I've done, go to Paris and make a noise about it.
Yeah.
But that's not the same.
Yeah. Well, you won't be surprised to hear that we don't think that that will necessarily complete the single market, make it work any better, and that's probably not going to get Europe growing and working again. No, I don't agree that that's necessary in order to complete the project and make it work better. In terms of Monty 2, in terms of Viking Naval, again, you won't be surprised to hear that the employers think that the judgments were reasonable, that they think that the implementation of the directive needs to be looked at, and in particular to avoid things like letterbox companies happening. They agree that there's not enough information available and guidance available on this, but they don't think that the directive needs to be reviewed. And I don't see how we're going to get through that impasse, to be honest, but I'd be very interested in views from the panel and from the audience on how we might, on where we might, there might be some movement. Was David's question the last one? On how we... Thanks.
I'd have tried to duck that one, actually, rather than...
Well, I agree that the fiscal treaty isn't the answer, and in a sense it's just wrapping up again rules that are already there and that were flouted in the first place, and who's to say that they're going to be abided by again this time round. The real problem is that the economies weren't convergent when they joined, and that's what's creating the crisis right now. And until there's some kind of action to make those members of the Eurozone more convergent, they're not going to resist these shocks time and time again.
Thanks very much. John?
Yes, just quickly on the 5 questions. Firstly, what difference is it going to make to Britain not being in the treaty, along with the Czech Republic now, by the way? I suspect the answer is not much, and this was, I think David Seymour mentioned it, it was a veto that never was, really. It's evaporated. The Prime Minister's now agreed that to allow the European Union facilities to be used, including the European Court of Justice, by the 25 countries that were negotiating the treaty. What it has done, or it might well have done, we shall have to wait and see exactly, it may have reduced the UK's prestige and standing generally in the European Union, given the row that took place before Christmas and so on. On the other hand, you don't know. I mean, memories are short and there's other deals to be done tomorrow, and people are rather pragmatic at the end of it. So, I mean, the ones who are upset about what's happened in the last 10 days are the Eurosceptics and the Conservative Party, because in a sense, with some warlike noises, the Prime Minister has allowed the treaty to go through. Should Greece leave the Eurozone and so on? Well, I personally don't know how it's going to be done. I haven't the faintest idea how you do it. They've got a single currency. They've got euros. And if they default, it's a bit like a state of the United States defaulting in America. And they have defaulted in the past, and the other states have not been too badly affected, except the banks who are holding the debt are the ones that go down. And in the case of Greece, that's the Greek banks, that's the French banks, top of the foreign banks, German second, British third. So the knock-on effects are most likely to come through the banking system. But, why don't they go back to the drachma? Well, if the debts at the moment are in euros, if you go back to the drachma, even assuming you could do that, and I don't know how you do that in a short time, then your debts are a lot more because the drachma would be relatively worthless compared to the euro. So there's not an easy option about Greece. I mean, this is one of the things that around in the British debate, that Greece should get out the euro and so on. It's not that easy, at least technically. I've not had been asking around how would it be done, were it to be done, and the answer is nobody seems to know. I totally agree with Roger Lyons, and not only I agree, but I think the International Labour Organization agree. In the recent Balpa case, I see Graham Fowler, Deputy General Secretary of Balpa over there, the ILO have said the British law, in particular, is far too restrictive, and the judgment in the Balpa case, which was based on the Viking case to a large extent, makes it a lot worse. So, and this brings you on to Catherine Barnard's point, that the ILO judgment seems to me to be the place where the European Commission should have started on the Monti II regulation, and that is a more liberal one based on human rights. I accept the point that there's always going to be some limits. It's not an unlimited right, but that the limits which in the present consultative text of the European Commission on the Monti II regulation, I think, are too restrictive. And there is, as you say, a danger that we'll find ourselves in the union world opposing it. Don't want to do that because there is an opportunity here. And Monti was trying to respond to trade union concerns, not make things worse. What's the way out? David said, I don't think there's an easy answer to that, but I mean, from my perspective, I think the perspective of the trade unions in Europe, it would be for a more expansive economic policy with the European Central Bank doing quantitative easing, like the Bank of England and the Federal Reserve are doing, like the Eurobond system, whereby the broadest shoulders carry more of the debt and help the weaker countries who are not going to escape from their debts on their own. But that's running up against Berlin and very, very strongly. Don't forget, most of Germans still don't have a credit card. They're like your grandmother. They're not like us, and so on. So their attitude to debt is 50 years ago British style, and the way we've gone, it's a pretty good thing at the moment. It didn't look like that 5 years ago, but it does look like that now. Harmonisation and all that on all the terms and conditions, I don't think that's realistic. You've got to keep pay in line with productivity, and at the moment there's huge gaps in European countries' productivity. Although it's a long-term trade union dream, you, for example, couldn't have minimum wages that are relevant in Germany and relevant in Poland because the standard of living is is quite wide. It's narrowing, I might say. That one of the great things, actually, not good, great things about the European Union is that when people have joined, until this current crisis, they closed the gap on the richer countries. it was one of the few areas in the world where you could point to equality developing rather than inequality. So I hope if and when we're through this crisis, that process will resume. But we're a long way from that yet. But what we do want to see harmonisation on is on some of these things on labour rights and workers' rights and so on. And particularly where transnational issues are concerned, we want to see the clear rules that apply Europe-wide and give unions a chance against the free movement of capital and particularly the free movement of capital and what the hedge funds are doing and the private equity lot are doing, whizzing around from country to country with no restriction at all, and very little that anybody can do about it, including us.
Thank you very much indeed. Anne, I think you get the final word here. That's a luxury not to be squandered.
Yes, goodness, the pressure's on. I'm not going to attempt to answer all of those questions. I'm going to stick to what I know. So just picking up on the point about cross-border industrial action, I think that's a very interesting point and obviously raises broader questions about the UK's approach to sympathy strikes more generally. But I think there's certainly a strong case for saying that European law encourages, for example, through the European Works Council's directive, workers to try and think about themselves as Europeans as well as just participants in national industrial relations. And the fact that that can't then be backed up by any kind of collective action is extremely problematic. Of course, there's nothing that the EU can do about this because the EU has no competence to legislate on the right to strike. And of course, that's part of the overriding problem here with the relationship between the right to strike and the internal market. And I completely agree with Catherine's point. I think leaving things as they are with Viking and Laval is not really going to work. Of course, we have to wait and see what comes out of Monti 2 and what the exact drafting is. But at least it offers the hope of making some difference. I did make the point that the right to strike can't be an unlimited right, but that's got to be the starting point in the reasoning, not the rules of the internal market, although we can't pretend that those rules don't exist and won't carry some weight in the broader sort of logical context of EU law. Thank you.
Well, thank you very much indeed for that. We're dead on time for a tea and coffee break before our next session, but can I ask you to thank again our panellists for this afternoon, Anne and John and Karen. Thank you.